We'll be starting with position number 1, Atkins.
Good afternoon, Ms. Atkins. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you, Ms. Atkins. You've been charged in case 23 CR 003399Y with reckless conduct. Is there a history, Ms. Roberts?
Yes. One prior arrest from April of 2020 for possession of marijuana less than an ounce, and she completed PTI for that case. Nothing further.
Thank you, Ms. Roberts. Good afternoon, Ms. Falk.
Good afternoon, Your Honor. This incident happened May 29th of this year at 10:46 a.m. at the Quality Inn and Suites at 3900 Fulton Industrial Boulevard. The defendant had a fire that started in her room 103, that was rented out to her on May 28th. And when the fire was occurring, she failed to notify the staff and the occupants of the Quality Inn and Suites that there was a fire in her room. Additionally, she failed to call fire department or 911 and alert them that there was a fire, which endangered both the occupants of the Quality Inn and Suites and the staff members there. The current bond is set is $1,000 surety bond. We are asking that that remain as set. Stay away from the Quality Inn and Suites at 3900 Fulton Industrial Boulevard, Atlanta. No alcohol, drugs, or weapons. That's all for the state.
Yes, Ms. Wills. Good afternoon.
Good afternoon, Judge. Ms. Atkins is a native of Georgia. She is currently somewhat unemployed, but she does do some DoorDash delivery. So she does have very limited income. She received her high school diploma from Lamar County High, and she has an associate's from Fort Valley in social work. She denies the allegations as alleged. She states that she did notify hotel staff and that she does have witnesses that were with her when she relayed the message regarding this fire. I would ask that my client be given a signature on bond. She is unable to make her $1,000 surety bond at this time. Her last arrest was 2019 for a possession charge, and that is her only history. So for all of those reasons and in light of the charges, I would ask for a signature bond, Your Honor. And she has no objection to not to staying away from that Quality Inn.
It's a $2,000 signature bond through the jail. Stay away from the Quality Inn on Fulton Industrial Boulevard, and no drugs, alcohol, weapons while out on bond. Good luck to you, Ms. Atkins.
Thank you. Position 9, Guzman, and she does have a family in the gallery.
Thank you.
You're welcome.
Good afternoon, Ms. Guzman. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. You've been charged in case 23 CR 003407D with permitting to drive to violate state law. Is there a history, Ms. Roberts?
No, I'm showing first arrest. She's recommended for pretrial.
Okay. Permitting driver to violate state law. Ms. Falk?
Yes, Your Honor. This happened April 1st, 2023 at 2405 Roxborough Drive. A vehicle struck 2 female pedestrians who were walking on the side of the roadway and then drove away. This resulted for those 2 female pedestrians in fractures, lacerated liver, traumatic brain injury. One had a brain bleed, and abrasions and bruising. The officers then used the broken rear view mirror that was found at the scene, identified that as part of the vehicle, and then used the citywide camera system to locate the vehicle's tag number, which came back registered to Brenda Guzman. They then spoke to Gerardo Ordaz, who was the driver of the vehicle at the time. He did admit that he was driving his brother to work, turned around and was turning around because he had missed his turn and struck something. And then he got out of the vehicle, saw 2 women on the ground, panicked and fled the scene. He was 17 at the time of this incident and had no driver's license. Mr. Ordaz then took the vehicle to a friend's house and hid the car under a tarp, where it was then later recovered by officers. When questioned, Ms. Guzman stated she knew Ordaz was driving the car and that she when questioned about whether she knew Ordaz was driving the car, she stated she was in Florida at the time and that everyone had access to the vehicle. She also stated she was selling the car to Mr. Ordaz and had signed over the title. However, as the officer explained, Mr. Ordaz was 17 years old, could not legally register the vehicle, and was unlicensed at the time. We understand this is her first arrest, and therefore we are recommending a $3,000 signature bond through pretrial services, no alcohol, drugs, or weapons. That is all for the state.
Any objection to any of that, Ms. Wills?
No objection to the signature bond. I would like to know for the record that my client does deny the allegations as stated.
Okay, it'll be a $3,000 signature bond through pretrial, no drugs, alcohol, or weapons while out on bond. Good luck to you, Ms. Guzman.
Position 21, Ms. Stephens.
Good morning, Judge. This is one of the cases that I did request a breakout session on.
Okay, let's see. Would you like to go somewhere to someone else and hold the breakout for last, or would you like for us to do the breakout?
That's fine. If we want to hold the three positions I requested in the chat, we can do them all at once. That's probably easier.
Okay. The request is not in my chat, so if you wouldn't mind, let me know which cases need breakout rooms.
It's positions 19, 20, and 21.
Okay. And is that fine with your courtroom too?
Yeah, that's fine, Judge.
Okay, so and let me just ask everyone else, are we going to need a breakout room for any other cases aside for Ms. Holly's cases?
No, none for me, Your Honor.
Okay.
And
All
the
right.
ones that- Judge Morrow, the ones that need breakout is the 19, 20, and 21, correct?
Yes, that's right. And I do see a Spanish interpreter on the line, so whenever you all have the ability to put them in a breakout room, just let the court know.
Okay.
I actually already spoke to Mr. Mejia. I speak Spanish, so I don't need a breakout room to talk to him. We can go forward in court for him.
Okay, thank you.
I'm puzzled. Where are we? What position are we on?
I think they're getting settled in courtroom too, Ms. Bridgewater.
Okay. Okay. I just heard all this silence. I didn't.
Judge Morrow, we can go ahead. Did you want to do the breakout now? That's fine. I don't have.
Okay. All right, we'll do the breakouts for 19, 20, and 21 then. So let me know who needs to be in the breakout.
I do.
Okay, and Ms. Falk,
I do
Mr.
as well.
Mr. Young, Mr. Howard,
Yes, Judge.
Ms. Bridgewater.
I can join, but they're not
Okay.
my cases.
Well, that's fine, Ms. Wills. Happy to have you. Okay, we are back. Is this courtroom 2? Is this Ms. Stevens still?
Yes, it is, Judge.
Okay, thank you. Ms. Stevens, good afternoon. I'm Judge Eric Morrow. We've had an opportunity to discuss your case with your lawyer and with the state. It's going to be a $3,000 signature bond through the jail. You're going to be released to one of the public defender's investigators and transported after you go home to Anchor Mental Health. You can.
Been to Anchor. I just got out of Anchor a couple of weeks ago.
Okay, all right, Ms.
I
Stevens.
don't need
And,
to go back to Anchor.
okay, well, that,
I'm psychiatric problem.
okay, so hold on, Ms. Stevens. So that's what we've agreed upon here today. And you're not to make any 911 emergency unless it's an actual emergency, okay?
I won't be making any more.
All right, good luck to you, Ms. Stevens.
Love to you all too, and thank you.
Thank you. And I'm sure Ms. Holly, you'll get in touch with her and explain what's.
And
what's-
I spoke to LaConya, so he'll talk to you tonight, okay?
Yes, thank you.
Sure. Okay, thank you. Okay, and then position 19 was also in the breakout.
Yes, 19 and 20 we've discussed. So if you want to bring,
Come on, Mr. Silva. This is position 19, Mr. Silva.
good afternoon, Mr. Silva. I'm Judge Eric Morrow. We have also had an opportunity to discuss your case with your lawyer and the state in a breakout room. The bond is going to be a $2,000 good bond. You're to stay away from the Bobby Dodd Stadium. We're going to have a mental health evaluation, and you are going to be reset to the calendar on June 8th. So we'll see you back. Well, you'll be heard again on June 8th. Okay. Good luck to you, Mr. Silva.
Thank you.
And for position 20, they waived their appearance.
Okay. We'll need Ms. Holly, if he's not there, I guess a written waiver.
Judge, he actively said he was not waiving his appearance.
Okay, so he just wouldn't come, is that right?
Correct.
Officer Francois, when you, did you all try to get him down?
Oh, so go ahead, Lawrence.
Your Honor,
Yes, Officer Norris.
yes, I tried to put Mr. Sotelo on the phone, but he was unruly. He wasn't listening to what we were telling him to say.
Okay.
I asked Ms. Holly if she could put him on the competency calendar.
Well, he's gonna go on the competency calendar.
Yeah.
I'm gonna see him again well, I'll see him on Thursday. So he'll be on the competency calendar on Thursday. But as far as today goes, it's gonna be
He's a little combative, Your Honor. I can bring him in, but
okay.
he's a little combative.
Ms. Holly, what's your pleasure on this?
She heard him on the phone.
Judge, I think that if the court is comfortable with him not being here, as long as he's on competency on Thursday, I'm okay with that.
Okay. All right. So it's going to be $1,000 good bond. He's to stay away from 2 MLK Drive, and he's going to be placed on the competency calendar on Thursday,
Thank you.
June 1st. Okay. So thank you all.
And
Who do
Mr.
we-
Howard said that he was going to go and try to see him this afternoon or tomorrow morning as well.
Okay.
With our social worker, so.
Very good. Thank you. Yes. Who do we have next?
Position 5, Carmichael, and he also has a family member in the gallery.
Okay. Thank you. Good afternoon, Mr. Carmichael. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, thanks.
Thank you. Mr. Carmichael, you've been charged in case 23 CR 003397Y with battery. Is there a history? Ms. Roberts?
Yes, 4 cycles. Last arrest was June of 2015 for battery family violence. That case was dismissed. He had a 2013 battery that was also dismissed, a traffic offense conviction in 2007, and 1 FTA in 1991. And nothing further.
Yes, Mr. Young?
Yes, Your Honor, this incident occurred on May 30th, 2023 at 3061 McMurray Drive Southwest. The law enforcement responded to this incident location and spoke with the victim, Demetri Henry. We would also ask the court to sound for him when appropriate. Our office had some contact with him, but the victim told officers that the accused is his landlord. The accused began striking his bedroom door with a broomstick before forcing his way into the bedroom and then striking the defendant with the broom, causing bruising and a break in the skin. Law enforcement did observe damage in the room. The victim says that he rents a room at this location. Police has been called 5 times in regards to his issues with the landlord. There is an eviction filed against the victim that he is disputing as he still remains there. He wants a no further contact and a stay away order as he is afraid of the defendant. The state's recommendation is a $4,000 surety, a stay away from that location, no further contact, 1-day anger awareness, and no alcohol, drugs, or weapons. And that's all for the state.
Okay, Ms. Wills, is this your case?
Yes, Your Honor.
I'm not sure who the family member is in the galley. Would you like me to hear from them
I
first?
have not spoken with anyone from Mr. Carmichael's family.
What's your pleasure?
I'm not sure what context. I would go ahead and say no, because I have not spoken with anyone outside of Mr. Carmichael about this incident.
Okay, let me see who is in the galley.
Yes or no, Norm? No, she's not the victim, Judge,
Oh, okay, thank you.
but she did speak to you, Judge.
Is it a family member?
Yes.
Yes.
Does she have knowledge of any of this incident?
Yes.
Okay, well, I'll hear from her.
Okay, Mr. Carmichael, stand over there on the wall for me. Stand on the other side of the.
Yes, ma'am. If you raise your right hand for me, do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you have to speak, but you can put your hand down. You have to speak up for me. What's your name?
My name is Andrea Norwood.
Miss Norwood. How are you related to Mr. Carmichael?
I'm his niece.
Okay, and what do you know about this incident?
So he's keeping his grandkids this week. The kids were the ones banging on this guy's door. And it didn't have anything to do with him. He came out yelling at them about banging on the door and yelling at my uncle.
Okay.
This wasn't about, my uncle wasn't the person that was banging on his door. And I didn't think that the person that was banging on the door, he's not old enough to come to court. But the children that were banging on the person that was banging on the door was a 5-year-old. And he was the one banging on the door. My uncle was not bothering him. And that's my uncle's residence that he lived in, that he was evicted.
Okay, and has he already been evicted, or he's just in the process?
I don't know. The police gave us paperwork for his eviction, so I don't know if it is prior to, or he is already supposed to have already been out by now. But I know that we had to pay. The police gave us the paperwork of his eviction. So
Okay. All right.
my uncle's a real estate broker. He owns the property that they were having an altercation at. But like I said, he has the kids, and the kids also stated that he didn't hit them. He doesn't want to move out of the home.
Okay. Thank you, Ms. Norwood. Anything further? All right, thank you. Ms. Wills?
Thank you, Judge. Mr. Carmichael is 79 years old. He has resided in the state of Georgia for the past 45 years. He is currently retired from the state of Georgia, where he was an accountant for 18 years with the state. And he also was an accountant through other companies and organizations. He has diplomas from Tuskegee as well as the University of Washington. He is an Air Force veteran, and he served for 4 years. As Ms. Norwood was stating, this is an instance between Mr. Carmichael and his tenant who does not want to leave. Mr. Carmichael has filed all the necessary paperwork to have this tenant evicted. However, he refuses to leave and is essentially a squatter at this point. Mr. Carmichael is, in speaking with him, he's willing to go through the judicial process, and it's his understanding that he is just waiting for his day in court or for the marshal to come to the home and escort the complaining witness off of the property. My client feels confident, though. Again, this is his home. He was renting a room to this gentleman. He does not have anywhere to go. Again, he is 79. I would ask for a signature on bond. My client is confident that there will be no further issues between himself and the complaining witness. He just would like for him to move out per the eviction notice that he received. My client denies the allegations as alleged. He does note that there was a verbal dispute because the children were playing loudly and slamming doors, and the tenant became upset. But he does feel confident they can live together without any further issues until they have a court date. But my client says he has absolutely nowhere else to go.
Your Honor, if I may briefly, there has not been an order of eviction. So as far as that goes, it's still a civil dispute. And although the defendant claims that the victim is a squatter and whatever the dispute is between them two, I'm pretty sure that the victim has his own version of the events as far as the circumstances revolving around their arrangement right now. So the state would still ask for a stay away and no further contact.
Okay. It's going to be a $3,000 signature bond through pretrial per the judge. No further violent contact with the alleged victim, Mr. Henry, and no drugs, alcohol, or weapons while out on bond. I'm not going to keep Mr. Carmichael from his home, but if there are any other incidents, and I'm going to let the judicial process play out as far as the eviction goes, and however that goes, it's given that it is Mr. Carmichael's home. But if there are any more incidents, Mr. Carmichael, and you end up back here, you won't get a signature bond or be able to go back if there are any further allegations. So good luck to you, sir.
Thank you, sir.
You're welcome.
Thank you, Judge.
Position 16, Phillips. Did you want to speak?
Hold on.
Also, we have a visitor for Mr. Phillips, and she does want to speak.
Okay, thank you. Good afternoon, Mr. Phillips. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
No, sir.
No?
Yes, I do have you.
Okay. You've been charged in case 23 CR 003403F with a fray. Is there a history?
No history.
Okay, Ms. Falk?
Yes, Your Honor. If I may, can we also bring up Ronye Brown and have him just sit in that first set of benches? Because these are co-defendants, well, cross-defendants, actually.
Okay. Is that possible?
He can go next, Judge. You just can't
Okay.
sit the front row because we have the females, but he can go next.
Understood.
Okay.
That's fine as well.
And he can hear this, right? So,
Yes, he's here.
okay.
What's
Brown.
Brown? Okay. You go next. Okay.
All right, so the fact pattern I'm going to read is for both of them, Judge Morrow. This happened May 29th at 6:42 p.m. at 7237 Walton Hill in South Fulton. Defendant Phillips advised that his stepbrother, Defendant Brown, and the defendant Brown was in a verbal dispute with their mother, Kenesha Brown. Defendant Phillips stated that things became physical, and in protection for his mother, he jumped in and he and defendant Brown began to fight in the front yard. Defendant Phillips stated he was struck in the face by defendant Brown. When questioned, defendant Brown stated that he and Kenesha Brown, his stepmother, she was intoxicated and they were arguing, and defendant Phillips pulled up and stated, "What are you going to do? What did you say you were going to do to my mother?" And they began fighting. Defendant Brown stated that defendant Phillips struck him in the face several times. So since both of them were involved in an altercation, it happened on the front lawn, which is in public. So the state changed the charge to a fray and went forward on both of their cases. Since it is the first arrest for both, I looked at both of their histories. The state is recommending a $3,000 signature bond through pretrial services for both individuals, 1 day anger awareness, no alcohol, drugs, or weapons, and no further violent contact with one another.
Okay, and is Kenesha Brown both their mothers?
She is the stepmother of the other defendant, Your Honor.
So she
Okay.
is the stepmother of defendant Brown and the mother of defendant Phillips.
Okay, Ms. McLeod, you're representing Mr. Phillips?
I am, Your Honor.
Any objection to any of the requests of the state?
No, Your Honor.
Okay, so I don't know who that is in the galley, but if they want to address the court, I'm happy to allow them to address the court. If you all can just let whoever that is know in the galley that they're going to get signature bonds in this matter. If they still want to address me, I'm happy to hear from whomever it is.
Your Honor, I think it's my client's mom, and I don't think it will be.
And Your Honor, if it is Miss Kenesha Brown, I would advise the court that she was cited for simple assault in all of this as well.
Oh, okay, so she's got
Yes.
pending charges. Okay, well, thank you.
Hey, Norris, that they're getting sick,
The-
but she still wants to speak. She said she didn't want to speak.
Okay,
If you want me, I want to deny, other than that. I heard what you said. No, she doesn't want to speak, Judge.
okay, very good. So just put Mr. Phillips back in the chair for me. Okay, Mr. Phillips, it's going to be a $3,000 signature bond through pretrial, 1 day anger awareness, and no drugs, alcohol, weapons while you're out on bond, and no further violent contact with your brother, Ronye Brown. Okay?
Yes, sir.
All right, good luck to you, Mr. Phillips. And can I see Mr. Ronye Brown?
And I would also like the court to know that they do not live together.
Okay, thank you. So just Miss Kenesha Brown lives at the Walton Hill address?
Actually, she doesn't live there. Her husband lives there, Your Honor. My client and his mom live at a different address.
Okay. And who's representing Ronye Brown?
I do, Your Honor.
Okay. Good afternoon, Mr. Brown. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar.
Good afternoon.
Good afternoon, sir. We're doing this by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. You have been charged in case 23 CR 003402F with the fray. Let's see, Ms. Wills, do you have any objection to the $3,000 signature bond through pretrial, 1 day anger awareness, no further violent contact with Mr. Phillips, and no drugs, alcohol, or weapons while out on bond?
No, Your Honor. The only thing I wanted to know for the record is that my client does deny the allegations as stated by the state.
Okay, so I'm going to give you a signature bond, Mr. Brown. Good luck to you.
Thank you.
You're welcome.
And that was the pretrial, correct, Judge?
Yes, both of them were through pretrial.
Position 17, Ray.
Good afternoon, Ms. Ray. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Ms. Ray, you've been charged in case 23 CR 003391J with disrupting a public school. Is there a history, Ms. Roberts?
I show 18 cycles. Last arrest was October of 2019 for simple assault. 2 FTAs, 2014, 2016, 2 probation violations, both in 2016. Appears to have an open case in Odyssey for aggravated assault, possession of a firearm by a convicted felon, and possession of a firearm during the commission of a felony, 16 SC 145667. Appears to be on probation out of Clayton County for criminal damage to property, criminal trespass, and aggravated assault. From August of 2015, 10 years probation, a 2006 conviction for simple assault, and a 2017 conviction for 2 counts of theft by shoplifting, and 1 count of driving while license suspended or revoked, and nothing further.
Mr. Young?
Yes, Your Honor. This incident occurred back in April 20th of 2023 at 3116 Benjamin E. Mays Drive in Atlanta. This is the Young Middle School. The victims in this case, well, I'll get to that later. On this day,
Judge, I don't intend to interrupt. I apologize, Mr. Young. I received a notice of charge and case dismissal in this case. Are y'all going forward on these charges differently than what I was given?
there were originally two disrupting public school, and I believe the second one was generated for the officer to correct a warrant or whatnot, because I was confused as well when I first saw it. So
The notice of charge dismissal that I have says that no accusations will be filed. So I just want to clarify, because I did not speak with Ms. Ray under the impression that her case was being fully dismissed. Judge, I can forward a copy of this if the court would like to see it.
And Your Honor, if I can interject, we did
Yes.
file a notice of dismissal. There were 2 charges for disrupting public school. We filed a notice of dismissal as to 1 charge and proceeded on the other charge. If PD Holly would like an opportunity to speak with her client, she's welcome to do so. But the state is going forward and has filed an accusation on 1 count of disrupting public school.
Okay, then I would like to either be placed in a breakout room or the jail court can call my phone, and I'm happy to speak with her on the phone if that's easier.
Okay. What's easier for you, courtroom 2, of how Ms. Holly can speak with Ms. Ray?
I'm sorry, Judge. Say that again.
Attorney Holly needs to speak with Ms. Ray
Okay.
again regarding this, so however that's easiest for you all.
Ms. Holly, you can dial extension 2392.
Can you give me the full number, please?
Sure, it's gonna be 404-612-2392.
Okay, I'll call right now. Thank you.
You're welcome.
Okay. And I guess if we can take cases that don't involve Ms. Holly while she's on the phone.
Ms. Mathis, position 14.
Okay. Good afternoon, Ms. Mathis. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. You've been charged in case 23 CR 003408G with simple battery family violence. Is there a history, Ms. Roberts?
Arrest.
I'm sorry, I didn't catch. It was first arrest?
Yes.
Okay, thank you. Ms. Falk?
Yes, Your Honor. If you could repeat the name of the defendant, please.
Yes, position 14, Mathis.
Okay. Mathis. Yes, Your Honor. And just to let the court know, this also has a cross defendant. It's Orlando Hammond, which is position 10 on the calendar. So if we,
Okay,
I don't know if we can address Orlando Hammond, depending on whose case it is, but if we could address them both as well.
It is my case. I represent Mr. Hammonds.
Great. So the fact
Okay.
pattern is going to be the same as to both of them. So this happened May 28th, 2023 at 2265 Perry Boulevard Northwest. Defendant Mathis stated she was involved in an altercation with defendant Hammonds at that location where they both live. Defendant Mathis stated there was an argument between her and the defendant Hammonds, and when she attempted to ask him to leave, he began making threatening gestures toward her. Defendant Mathis stated she felt threatened and struck defendant Hammonds in self-defense. She stated she was also struck, and then when questioned, defendant Hammond stated he was attacked by defendant Mathis and did not make any threatening gestures. Defendant Mathis did not show visible injuries. Defendant Hammonds had injuries to his neck, chest, and upper arms, but neither the report or the warrant states what those injuries are, and he did not require any treatment. Both individuals were arrested. I will say, according to what I saw in pretrial, and I will ask pretrial to see if that is correct, defendant Mathis was showing with no previous history. Defendant Hammonds has 27 cycles. So defendant Hammonds' 27 cycles include several violent family violence convictions, a 2004 simple battery family violence conviction in February 9th of 2005, a 2017 aggravated assault, cruelty to children in the third degree, simple battery family violence conviction in February 13th of 2018, a 2020 battery family violence, cruelty to children in the third twice, 2 counts, that was convicted February 24th, 2000, and a 2022 aggravated assault where he was convicted in February 16th of 2023, given a 10-serve-1, which he is still on probation for because, as I stated, he was sentenced about 3 months ago. And all of those cases involve either aggravated assault, family violence battery, or aggravated assault family violence. So there is a lengthy history here of family violence and aggravated assault cases involving Mr. Hammonds, whereas there is no histories to Ms. Mathis. The state's recommendation is structured as follows. As to defendant Mathis, $3,000 signature bond through pretrial services, 1-day anger awareness, no alcohol, drugs, or weapons, and no further contact with Orlando Hammonds. As to Ms. Defendant Hammonds, the state's recommendation is a $10,000 surety bond, stay away from 2265 Perry Boulevard Northwest, no further contact with Jamaria Mathis, no alcohol, drugs, or weapons. That's all for the state.
okay. Let's see, Ms. McLeod, you're representing Ms. Mathis.
I am, Your Honor.
Any objections to the $3,000 signature bond through pretrial, 1-day anger awareness, no further contact, and the no drugs, alcohol, or weapons?
I'm fine with that, Your Honor. And I just wanted the court to note that the address in question is my client's home. She is the one who's on the lease. She's been living there for 5 years. And she said that her ex, you know, he would come over from time to time, but he doesn't really live there. And we're fine with the stay away, Your Honor.
Okay, so, well, I'm not gonna make her stay away, so.
No, Your
further
Honor, for him. She doesn't want him to come back there. He can have a one-time police escort to get his things.
Okay,
And
so
just to
as far as
clarify-
she,
Oh, sorry, Your Honor.
I was just gonna say,
Go ahead.
as far as she's concerned, she's to have no further contact with Mr. Hammond, but she, I'm not making her stay away from her Perry Boulevard address.
Thank you, Your Honor.
Okay, was that what you, Ms. Falk?
Yeah, I was just trying to clarify. State did not request a stay away from the address as to Ms. Mathis.
Right, okay. All right, Ms. Mathis, I'm giving you a signature bond, but you cannot not have any further contact with Mr. Hammond whatsoever. Okay, good luck to you, ma'am.
Thank you. Come on, man.
Okay. And
Thank
if
you.
we can have Mr. Hammond, please.
We have to get him out. He's in the back. We were trying to keep them separated. Hold on one second.
Okay, well, just let me know when, if you want to go to someone else, that's fine, but
Okay.
Your Honor, that concludes my business before the court today. May I be excused?
Yes, good to see you, Ms. McLeod. I hope things went well. I missed you in SAP this morning.
Yes, Your Honor, I was in court until almost
I-
1 o'clock.
We were informed. You've had a long day. Have a good day.
Thank you, Your Honor.
You can have a seat. This is gonna be position 10, Hammond. Have a seat in the green chair for me, Hammond.
And Your Honor, just to clarify, I know his name appears as Orlando Hammond, no S, on the calendar. However, under all of his previous sentences, his name has been Orlando, well, with the exception of the most recent one, his name has been Orlando Hammonds with an S. So I'm not sure which name he goes by, but it is interchangeable on his sentences.
Any clarification, Ms. Wills?
It should be Hammonds with an S on the end.
Okay, all right. Good afternoon, Mr. Hammonds. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. You've been charged in case 23 CR 003409G with simple battery family violence. I've already received your history and the allegations from the state. Ms. Wills.
Thank you, Judge. Mr. Hammonds is 42 years old. He is a native of Atlanta. He is currently employed by Wendy's as a cook, and he works at the Wendy's located on Howell Mill Road. He's been employed there for the past month. He does not qualify to be represented by the Public Defender's Office. He does have 3 children who are under the age of 18. He states that Ms. Mathis is his former girlfriend after this incident. He cannot afford bond whatsoever at this time. Mr. Hammond states that Ms. Mathis was in a bad mood this day, that she attacked him, punched him, scratched him, and that he is actually the victim of this incident. It was noted in the warrant that he is the only one who had any visible injuries. And I think that's proof positive there that he was not the aggressor, and definitely did not, he did not harm Ms. Mathis in the course of this incident. I would just ask that my client not be punished for his past record and that is not evidence that he is guilty of this offense. And I would ask for a bond, a signature bond. If Your Honor is not so inclined, I would ask for the bond to not exceed $1,000.
And Your Honor, we're not stating that this is proof of his guilt in this case, merely that it goes strongly toward the Ayala factor of risk of reoffense.
All right, it's going to be a $2,000 good bond, no further contact with Ms. Mathis. Stay away from the Perry Boulevard address. He can go back to that address on one occasion with law enforcement to retrieve any belongings that he might have there. No drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Hammonds.
What do they mean?
Ms. Wills will speak to you if you have questions regarding the bond. So if you'll give him a call after court, Ms. Wills, as he is inquiring as to my bond order.
Yes, Judge.
Thank you.
Going back to position 17, right?
Okay, Ms. Holly, are we ready to move forward?
We are, Judge.
Okay, so I think that I've already gotten the history and I have already received Mr. Young's recitation. If there's nothing further, Mr. Young, Ms. Holly.
Yes, Your Honor. So this incident actually occurred on April 20th, 2023, and Ms. Ray was actually released and given a separate court date on June 17th. She was not aware that a warrant had been taken out at the time. She will no longer be at that school for any reason. Her daughter actually graduated from that school, and so she has no issues with any stayaways. She is a single mom to 4 children, ages 14, 11, 8, and 5. Because of this and the fact that she is the primary caretaker for all of these children, we would request that she be given a signature bond. She's had no other issues with the school since this incident over a month ago. So we would just request a signature bond through pretrial so that she can return and deal with this.
Yeah, Your Honor, if I may, I didn't finish. I got to the victim and the location, but I didn't put the facts on the record. So if I may briefly do that.
Okay, of course, Mr. Young, go ahead, go ahead.
The defendant came to the school to speak with staff who were there mediating a fight that occurred between the defendant's daughter and another child. The defendant said in the presence of officer, there will be a round two. I hope she can fight. After waiting an hour to confront the other child and the other child's parents, the defendant ran up to the officer as he was escorting the other parties out of the building. The defendant came out yelling, "Is that them? Hold up. Are you about to tell me something?" and proceeded to call the child a little bully and a bitch and saying that I will beat your ass. At this point, the parties entered back into the building and the two children began fighting. As we've heard from pretrial, the defendant has a history of violence. She has pending cases. She's on probation for violent offenses. So the state's recommendation is a $4,000 surety bond, 1-day anger awareness, no alcohol, drugs, or weapons, no further contact with ST, and that is the minor victim, Shanika Hargrove, the minor's mother, and Latavius Thomas, the minor's father, and a stay away from the school.
Your Honor, I would like to point out that the open case that's in Superior Court has a 2016 incident date, and there has been no movement on the case since October of 2016 as of Odyssey.
Okay. Hargrove, and what was the other name, Mr. Young? I mean, the child, ST, Hargrove, and
Latavius Thomas, the minor's father, Latavius Thomas.
Okay. All right, it's going to be a $3,000 signature bond through pretrial per the judge, 1-day anger awareness, no further stay away from Young Middle School on Benjamin E. Mays, no further contact with Mr. Thomas, Ms. Hargrove, or the minor ST, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Ms. Ray.
Thank you.
You're welcome.
Position 3, Alan Brown.
Good afternoon, Mr. Brown. I am Judge Eric Morrow. Good afternoon, sir. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. You've been charged in case 23 CR 003401A with battery family violence and simple battery family violence. Is there a history, Ms. Roberts?
Showing 3 cycles. Last arrest, March of 2020 for battery family violence. He completed PTI for that case. He has no convictions. Nothing further.
Ms. Falk?
Yes, Your Honor. This incident happened June 18th, 2022 at 2:23 p.m. at Cascade Glen Apartments at 3909 Campbellton Road Southwest, apartment J7. Officers spoke with Nika Shea Williams, who had come into, who had spoken to police and told them that her ex-boyfriend, the defendant, had dragged her by her hair into her apartment, poured vinegar, liquor, and mouthwash on her, that he also grabbed her hair, slammed her to the ground, and spit in her face. Ms. Williams, as a result of this, had a scar on her right knee. She did also tell police that they had known each other for 7 years and had lived together for 2 years. We have had a chance to speak with Ms. Williams, who is here on the Zoom, and the state would like to sound for her. She stated that they are no longer in a relationship, no longer live together, and share no children. And she also indicated to our victim advocate that she no longer lives at that location and that there has been violence between them before, where they both have been arrested, but since this, no violence has occurred. Although she wants further contact, the state would object to further contact, especially given the in light of the fact that the defendant was arrested for and had a dismissed 2021 family violence battery. And plus the indications from Ms. Williams that there had been violence previously between the two of them. The state is recommending a $4,000 surety bond. That's $3,000 on the battery, $1,000 on the simple battery. No further contact with Nika Shea Williams. Stay away from, well, we're not asking for a stay away, being that that address, her residential address has changed, but no alcohol, drugs, or weapons. And the state would like to sound for Ms. Williams.
I see Ms. Williams on the line. Ms. Williams, if you would like to address the court, now is your opportunity to do so. I'll need for you to raise your right hand for me. Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you, ma'am. What would you like to tell the court?
I just wanted to say, me and Alan Brown are not together. He doesn't harass me. I don't fear for my life or anything like that. He lives his life, I live mine, and that's what it is.
Okay. Have you had contact with him in the last month or two? When's the last time?
Last month or two, no.
Okay.
Act-
I'm sorry, I didn't hear you, ma'am.
No, only
Oh.
yesterday.
Okay. Any questions, Ms. Falk?
I'm sorry, Ms. Williams, did you say you had contact with him yesterday?
I was dropping him off at home, and we got pulled over, and when they asked for his ID, that's when they pulled up that he had a warrant, and I was confused because it had happened last year.
Okay, but you do acknowledge that the defendant did strike you last year in June of 2022 and cause a scar to your knee.
He didn't punch me or slap me or anything like that. He just, slammed me on the ground and poured liquids on me. That was all.
And is that how you received the scar on your knee, or is it some other way?
Yes. No, that's how I received it.
Okay, thank you, Ms. Williams. Nothing further, Your Honor.
Yes, Ms. Wills.
Thank you, Judge. Mr. Brown is 36 years old. He is a native of Atlanta. He is an owner-operator through Atomic Transport, where he is a driver. He's been employed there for the past 3.5 years. He does have a high school diploma from Tri-Cities High School. He also attended trade school where he received his CDL. He does not have any children. As was stated, he has no convictions on his record. I do find this curious in looking at the warrant. The warrant was issued October 11th, 2022 for an incident that occurred in June 18th of 2022. And here we are almost a year later. I would request a signature on bond in light of my client's not having any criminal history. Also in light of what Ms. Williams has proffered to the court today. They've not lived together. They have been able to have a amicable relationship since that time. They are no longer in a romantic relationship. My client states that he was actually attacked by Ms. Williams. Anything he did was out of self-defense, but he does deny ever becoming physical with her. And that he did not pour any liquids on her either. So I am just curious to know how law enforcement had enough probable cause for a 4-month-old scar. But again, I would request a signature on bond, Your Honor.
Okay, for the battery, it's going to be a $3,000 signature bond through pretrial. For the simple battery, a $1,000 signature bond through pretrial, both per the judge. 1-day anger awareness, no further contact with Ms. Williams, and no drugs, alcohol, or weapons while out on bond. All right, good luck to you, Mr. Brown and Ms. Williams.
Thanks, sir.
Thank you.
You're welcome.
Judge, I have stepped away. Can you please repeat the bond?
3,000 signature bond through pretrial for the battery and a $1,000 signature bond through pretrial for the simple battery, making a total of a $4,000 signature bond through pretrial.
Thank you.
You're welcome.
And Your Honor, was that no further violent contact or no further contact?
That was no further contact, given the allegations.
Thank you.
Position 12, Jones.
Good afternoon, Mr. Jones. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Jones, you've been charged in case 23 CR 003390Y with battery family violence. Is there a history, Ms. Roberts?
Yes, 7 cycles, 1 out of Georgia, 6 out of Alabama. Last arrest was April of this year for simple battery family violence. That case number is 23 CR 002561Y. That is the same victim from today's case. He has 1 FTA in 2016 out of Alabama, and then all of his other arrests out of Alabama are all family offense, domestic violence, but they all have no disposition. The last was in 2019. Nothing further.
Mr. Young?
Yes, Your Honor. This incident occurred on May 29th, 2023 at 283 Sunset Drive in Atlanta. The victim in this case is Marquette Hunt. Law enforcement spoke with that victim, who stated that she was assaulted by a child's father, the defendant, Mr. Jones. She also told officers that there was an altercation about feeding their 4-month-old child. When she told the defendant to feed him, a verbal altercation occurred, but turned physical when the defendant grabbed the victim, pushed her, and struck her, causing an injury, bleeding, and swelling. She does not want contact with the defendant. She wants a stay away, but she would not be on Zoom. The state is aware of his open case. Your Honor, I'm bringing to your attention that on April 26, 2023, in case number 23 CR 002561Y, the court issued a $4,000 good bond, which included a no further contact with Marquette Hunt and a stay away from 283 Sunset Drive in regards to a simple battery family violence, per Judge Williams. This case has occurred less than a month after the first incident regarding the same victim. He had violated a court order by simply being at that resident around the defendant. And to make matters worse, he committed another battery against that victim. So the state is asking for a $4,000 cash bond, stay away, no further contact, 1-day anger awareness, no alcohol, drugs, or weapons.
Okay, Ms. Holly?
Yes, Judge. Mr. Jones is 32 years old, and she is the mother of his children. So they do share children together. He does have a job. He works at ADP in Alpharetta. He's also in the Army National Guard Reserves. We would ask the court to consider a couple of things. First of all, the fact that none of his cases have any no disposition, no convictions on any of these allegations. In addition, he denies these allegations and the allegations from the prior case, though I don't find them relevant other than the fact that it's the same person. He would allege that at trial he would show that there was violent contact made by her first and that he was defending himself. We would just ask for this to be a surety bond, a good bond, so that he can go back to work. He does, as far as he knows, still have his job at this point. And the victim also does have known mental health issues. So her mental health history also likely is contributing to who is initiating this violence. We would just like that to be on the record as well.
Yeah, and if I may briefly reiterate, it's the same person, and there was already no further contact order that was violated. Not to mention his history. Even if there are no convictions, there was at least enough probable cause for him to be arrested not once, but multiple times in different states for family violence crimes.
We do understand the prior order, and obviously we've had a discussion about there being a no contact order and what that means. He also understands that this may mean he is not able to see his children during the pendency of these cases.
Okay, so just so that I know that I've told Mr. Jones, myself personally, no contact. It means absolutely no contact. No phone contact, no personal contact, no internet contact, no social media contact, no contact whatsoever. And it bothers me that an order was entered previously ordering you to have no contact. You are presumed innocent of those charges, but you got a bond based on the fact that you were told not to have any contact whatsoever. Had that been the case, you might not be in the situation that you are currently in. So just so that I know that I've told you and that you know, no contact whatsoever with Ms. Hunt. I am always reticent. Do you have something, Ms. Falk?
No, Your Honor, I was just going to ask Mr. Young what that previous case number was.
The previous case number is 23 CR 002561Y.
Thank you.
Okay. As I was saying, I am always reticent to keep a father from his children. And I'm not going to do that in this case because I think that that your kids need to have you in your life, but you can have no contact with Ms. Hunt, which means that you have to have a third party to transfer the children for visitation. I'm not going to take that away from you because I think that it's important for you to be in their life. But again, you can have no contact with Ms. Hunt herself personally. It's going to be a $15,000 surety bond. No further contact with Ms. Hunt. Stay away from the Sunset Drive address. I don't know if he has any belongings there, Ms. Holly, but if he does, he can have a third party go and retrieve those belongings for him. No drugs, alcohol, weapons while out on bond.
Thank you.
Your client has a question, Ms. Holly. I don't know if that's something you need to.
Is it a question specifically about the bond or is it about the circumstances of the case?
About the bond.
Okay, you can ask a question about the bond.
Yes, I was told that I can get it, like, I'll let my PD know, the public defender know that I cannot go exceed $4,000 on a bond. I was trying to ask for a surety bond at least $2,000.
The judge is the one who sets your bond. So the judge has set a $15,000 surety bond. We can have a hearing later down the road if that bond needs to be modified. But for right now, Judge Morrow has ordered that it be set at $15,000 surety.
All right, good luck to you, Mr. Jones.
Yes, sir.
Position 6, Carter.
The Alpharetta Jail wanted me to go
Oh, I'm
there.
sorry, I forgot. Yes, that is correct. I did tell them, no problem.
Okay,
I forgot.
no, you're fine. If I just,
Where are they?
I see him sitting there, so.
Yes.
Who do we? Okay, thank you. Who do we have at the Alpharetta Jail?
I have Mr. Efrain Matera. Najia.
Okay, I believe this is position number 13. And is it Mokeda? Okay. Yes, good afternoon, Mr. Mokeda. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Buenos días, señor Maqueda. Yo soy el juez Morro del Tribunal de aquí de Estatal de Fulton. Estamos llevando a cabo el horario de calendarios para hacerlo más rápido. ¿Usted está de acuerdo en tener su audiencia en Zoom? He said yes, Your Honor. Let me ask him to open his microphone. Señor Maqueda, por favor, active el micrófono para poderlo escuchar. ¿Está de acuerdo en que se lleve a cabo esta audiencia en Zoom? Yes.
Okay, and Madam Interpreter, I'm sorry, I was not realizing that this was the case that that you're here for us for. So given that, can you raise your right hand for me? Do you swear or affirm that you will translate from Spanish to English and English to Spanish to the best of your ability?
I do, Your Honor. May I ask everyone to please pause so I'm able to interpret for Mr. Maqueda.
Okay, thank you.
Thank you.
Mr. Maqueda, you have been charged with 3 counts of cruelty to children in the 3rd degree and 1 count of battery family violence.
Señor Maqueda, usted lo acusan por 3 cargos de crueldad hacia menores en el 3er grado y también por lesiones debido a la violencia intrafamiliar.
Is there a history, Ms. Roberts?
¿Hay historial, Están preguntando a otro oficial.
5 cycles. DUI conviction 2020.
Can you repeat for the interpreter, please, what you said in the beginning?
5 cycles.
Tiene 5 ciclos.
DUI conviction 2020.
En el 2020 tuvo una condena por manejar bajo los efectos del alcohol.
Driving without a valid license conviction 2009.
En el 2009 tuvo una condena por manejar sin licencia válida.
Nothing to add.
También no tenía una matrícula.
Mr. Young,
Yes, Your Honor. This incident occurred on May 29, 2023 at 6015 State Bridge Road in Johns Creek. The victim in this case,
I'm sorry, 1615. What was the address, please?
it is 6015
Okay.
State Bridge Road in Johns Creek.
State Free Road in Jones Creek. Okay. Este incidente ocurrió el 29 de mayo de 2023 en 6015 State Free Road en Jones Creek.
The victim in this case is Alpha Espinoza.
La víctima en este caso es Alfa Espinosa.
From my understanding, our office has not had any contact. However, we would ask the court to sound for her when appropriate.
También nos indicaron que no se pudieron contactar con la señorita Espinosa, pero están pidiendo que si está presente que se deje saber.
The
go ahead,
victim
Mr. Young.
the victim reported that the child's father, the defendant, was trying to hit her and refusing to leave.
La víctima nos indicó que el padre de los niños, el acusado, le estaba pegando y se rehusaba a irse.
She stated that he arrived heavily intoxicated and became aggressive toward her as she prepared dinner.
Ella dijo que él llegó en estado de embriaguez y se dirigió a ella de una manera violenta mientras ella estaba preparando la cena.
She says that the accused struck her, which caused redness and pain in her ear.
Ella dice que el acusado le pegó, lo que le ocasionó que se le pusiera de color enrojecido el cuello.
All
y
the
la oreja.
juvenile children were present to see or hear the incident.
Todos los niños menores de edad estuvieron presentes y oyeron y vieron el incidente ocurrido.
The state is concerned about the safety of the victim. Therefore, we are asking for a $6,000 surety bond.
La fiscalía se preocupa por la seguridad de la víctima, por lo tanto estamos pidiendo que se le imponga una fianza, una caución de $6,000.
The breakdown of the bond being $3,000 for the battery family violence and $1,000 per cruelty in the third degree.
La forma como está haciendo esta fianza son $3,000 por la violencia y con lesiones y $1,000 por la crueldad hacia los niños, por cada uno de los cargos de crueldad hacia menores.
We are also asking for a stay away from the incident location, no further contact with the victim, no alcohol, drugs, or weapons, and one-day anger awareness.
También estamos pidiendo que se mantenga alejado del sitio donde ocurrió el incidente, no contacto con la víctima, no puede utilizar armas, ni drogas, ni alcohol, y que haga un programa de un día de cómo controlar el temperamento.
That's all for the state.
Eso es todo lo que está pidiendo la fiscalía.
Ms. Holly?
Yes, Your Honor. Ms. Mejia is 32 years old.
El señor Mejía tiene 32 años de edad.
And he denies the allegations as described in the police report and warrants.
Y él niega los alegatos que se hicieron, que se pusieron a la vista en el informe de policía y en la orden de arresto. Él está negando todo lo que dicen estos informes.
He would state that the violent contact was initiated by Ms. Espinosa.
Él dice que el contacto violento fue iniciado, lo propició la señorita Espinosa.
As stated, Mr. Mejia is 32 years old and he has no violent history in his record at all.
Como dije anteriormente, el señor Mejía tiene 32 años, no tiene ningún tipo de antecedente de violencia en sus antecedentes penales.
He also has a good job working as an air conditioning tech, doing contract work installing air conditioning systems.
También tiene un buen trabajo trabajando como técnico de aires acondicionados, donde instala los aires acondicionados y los mantiene, les da mantenimiento.
Judge, we would ask for a $6,000 signature bond.
Pues, señoría, vamos a pedir por una fianza que sea una fianza bajo palabra de $6,000, pero una fianza bajo palabra.
And we would request that all of the conditions can be the same, the way the state stated them. So a stay away, no further contact, no drugs, alcohol, and weapons, and a one-day anger management.
Entonces vamos a pedir que las demás condiciones se mantengan iguales como la pidió la fiscalía, que se mantenga alejado del sitio, no contacto con la víctima, no puede usar armas, ni alcohol, ni drogas, y que tiene que hacer un programa de un día de cómo controlar el temperamento.
We would just ask that the court add that there be a third-party transfer of the children if the court is inclined to allow him to maintain contact with them.
Lo que sí vamos a pedir es que el juez establezca o asigne una persona de una tercera persona para que pueda haber transporte para poder ver los menores de edad si el juez así lo decide o lo permite.
That's all for now, Judge. Thank you.
Eso es todo por ahora. Gracias.
Okay, for each of the cruelty to children in the third degree, it's going to be $1,000 signature bond through the jail.
Va a ser una fianza de $100,000 de bajo palabra y también es $1,000 por cada uno de los cargos de crueldad hacia menores, pero con una fianza bajo palabra.
For the battery family violence, it's going to be a $3,000 signature bond through the jail.
Y también para la violencia con lesiones bajo violencia intrafamiliar va a ser una fianza bajo palabra de $3,000 por medio de la cárcel.
That makes for a total of a $6,000 signature bond through the jail.
Eso hace un total de $6,000 de fianza bajo palabra, bajo la firma o bajo palabra a través de la cárcel.
No further contact with Alpha Espinosa.
No puede tener más contacto con Alfa Espinosa.
Stay away from the 6015 State Bridge Road address.
Manténgase alejado de la dirección de 6015 State Free Road, de esa dirección.
He can go back to that address on one occasion with law enforcement to retrieve any belongings that he might have there.
Usted puede regresar a esa dirección acompañado de una persona del orden público para que pueda recuperar o sacar sus pertenencias una sola vez con un policía para que vaya a buscar sus pertenencias.
And there is to be third-party transfer of the minor children for visitation.
Y va a haber una tercera personas que se encargarán del transporte para que pueda ver a los niños para visitas de los niños menores.
No drugs, alcohol, or weapons while out on bond.
Y no puede usar drogas ni alcohol ni usar armas de fuego mientras esté bajo libertad vigilada, bajo
And
fianza.
just let me explain what no contact means. No contact means absolutely no contact.
Y déjeme explicar lo que significa que no puede tener contacto. Es decir, no puede tener ningún tipo de contacto en absoluto, nada de contacto con la víctima.
No phone contact, no personal contact, no internet contact.
No puede tener contacto por teléfono, personal o por la internet, ningún tipo de contacto con la víctima.
And you will have to consult a third person to transfer your children. So even with the children, you can have no contact with Ms. Espinosa.
Y usted tiene que buscar una tercera persona que se encargue del transporte y de arreglar todo para la visita de los niños, porque usted no puede tener ningún tipo de contacto con ella, ni siquiera para esto de las visitas de los niños. Tiene que ser organizado por una tercera persona.
Ms. Holly, anything further that I need to explain to him?
No,
¿Algo
thank you,
más?
Judge.
No, gracias.
Okay. Good luck to you, sir.
Buena suerte, señor.
Okay. And do we need a Madam Interpreter for any other cases this afternoon?
No more of my cases.
And none for my cases, Judge.
Thank you so much for being here. We appreciate your assistance today.
You're very welcome, Your Honor. Everybody have a
Gracias,
nice
señora
day.
Lin.
De nada, hasta luego.
Thank you. Who do we have next?
Position 6, Carter.
Good afternoon, Mr. Carter. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're conducting by video. Do you agree to have your case heard by video? I'm sorry, was that a yes?
Yes, sir.
Okay, thank you. Mr. Carter, you've been charged in case 23 CR 003404B with reckless conduct and willful obstruction of a law enforcement officer. Is there a history, Ms. Roberts?
12 cycles, 4 out of Georgia, 8 out of Illinois. Last arrest, August of 2022 for aggravated battery. That is an open case, 22 CP 211910. One conviction out of Illinois for theft in 2015, and then a 2018 and 2019 FTA. Nothing further.
Ms. Fall?
Yes, Your Honor. This happened May 28th, 2023 at Topgolf at 1600 Ellsworth Industrial Boulevard. The officers were told that there were 3 males inside bay 311 of that location. One of them was waving a firearm back and forth, stating he would air out the building. Cindy Henderson, who's an employee at that location, was their server and stated she reported this to police because she was scared when she saw the defendant waving a gun around and making those statements. The officers then arrived and spoke with the male, the defendant matching in bay 311, who matched the description provided by Ms. Henderson. Although no firearms were found on their person, he told them to stay put so he could go observe the cameras and see if he could see whether one of them had a firearm. At that point, the defendant jumped up, went down the stairs and ran across the street and hid from the officers inside of a bush in the woods. The officer was able to locate him and place him in handcuffs. Around the same time all this was happening, a car was seen speeding away from the location, and it is believed that a gun may have been handed off to someone in that vehicle. I will state that the defendant's pending case, the 22 CP 211910 case. He was given a $15,000 surety bond, and as part of the conditions of that was told to have no weapons. So we are of the opinion, well, not of the opinion, our allegation is that he has violated the conditions in terms of those bonds. Additionally, given the fact that this happened in a building which had multiple people inside of it and caused this much concern for the person who is working there, we feel that this defendant is not only a danger to himself, but is a danger to other people. For that reason, the state is recommending a $21,000 surety bond. We're recommending $20,000 for the reckless conduct, $1,000 for the obstruction. Stay away from Topgolf at 1600 Ellsworth Industrial Boulevard. No further contact with Sydney Henderson. Surrender all firearms to Fulton County Sheriff's Office. No alcohol, drugs, or weapons. That is all.
Ms. Wells?
Thank you, Judge. Mr. Carter is 30 years old. He has resided in the state of Georgia for the past 5 years. He reports that he is employed by One Nation Music Group as an artist, and he's been their artist for the past 4 years and 4 months. He will not qualify to be represented by the Public Defender's Office. He has received his bachelor's degree in computer science from Miles College. He has 2 children aged 5 and 6. I didn't hear, other than the open case, which is not a conviction, history of violence for my client. I heard a 2018-19 FTA and a 2015 theft. Again, the gun in this situation, the alleged gun was not located. There is no independent evidence that was presented that my client had a weapon. One was not found on the premises or property. My client was not in custody or detained when law enforcement showed up to Topgolf. He has the freedom and right to move and leave if he so chooses. Many people are fearful of law enforcement and wish not to interact with them. For all of those reasons, I would ask for a signature on bond. If Your Honor is not so inclined, I would ask for a bond not to exceed $3,000.
And Your Honor, the simple reason the state pointed out the existing case was not because he's been convicted on it, but because there were a condition of bond that he have no weapons. Additionally, he was not free to leave. He was the subject of an investigation, was told to remain seated by the officers, and then took off running, which is the basis for the obstruction.
Excuse me. It's going to be a $2,000 surety bond per charge, makes for a total of a $4,000 surety bond. Stay away from Topgolf on Ellsworth Drive. No further contact with Sydney Henderson. Surrender all firearms. no drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Carter.
Position 8, Cruz.
Good afternoon, Mr. Cruz. I'm Judge Eric Morrow. This is the State Court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Cruz, you've been charged in case 23 CR 003405Y with battery family violence. Is there a history, Ms. Roberts?
7 cycles. Last arrest was March of this year for FTA and a probation violation out of Cherokee County. Appears to be on probation out of Cherokee County for possession of a Schedule 1 or 2 controlled substance with intent to distribute and possession of a firearm during the commission of a felony. Disposition November of 2018, 10 years probation, and then 2 other probation violations, 2019 and 2020. Nothing further.
Ms. Falk?
Yes, Your Honor. This incident happened March 5th, 2022. Ashley Sandifer reported to Zone 6 Police Precinct that she was the victim of domestic violence. She stated she was at the Texaco at 689 Boulevard Northeast when the defendant became aggressive with her, pulled her into the vehicle. As he was driving, he began pulling on her hair and tried to smash her head into the steering wheel. The defendant was cursing and yelling at her. She stated when she tried to talk back, he stuck his fingers down her throat, and when they arrived at 70 Providence Drive in Covington, the defendant grabbed her by the throat and was squeezing. Ms. Sandifer stated when it became difficult for her to breathe, he let go. At the time of the incident, they did share a 6-month-old child, and the officers noted that that Ms. Sandifer had visible patches of hair missing from her head. I will state that we have had a chance to speak with Ms. Sandifer, who is here on the Zoom, and we will sound for her at the end of our recitation of facts. They are in a relationship, they live together, they do share a child, and she is currently pregnant by the defendant. She did confirm the events that we spoke with her in the warrant about. According to our victim advocate, Ms. Sandifer stated the defendant pulled out her hair and choked her to the point that she could not breathe, and it was blocking off her airway. But she said she did not feel like she was going to pass out. She is also saying she wants him to return back to the residence. However, due to the facts of this case, we do have some grave concerns about a risk of reoffense, being that this was a fairly severe case given the facts. The state's recommendation is a $5,000 surety bond, no further contact with Ashley Sandifer, no alcohol, drugs, or weapons. We are also pointing out that he is on first offender currently on that 2018 Schedule 1 or 2 case, possession of drugs and possession of firearm during commission of a felony out of Cherokee County, as well as he concluded 3 years of probation on a 2018 case and has a 2023 FTA and probation violation out of Cherokee County arrest, as well as a 2020 probation violation out of Canton, where he received 60 days in jail. That is all for the state. And we would like to sound from Ms. Sandifer.
Ms. Sandifer, I see you there. If you would like to address the court, this is your opportunity to do so. If you would like to address the court, of course, you do not have to, but if you would like to, you'll have to unmute yourself and I'll have to swear you in. I'm not certain if that she does not want to address the court or she was having some issues. Ms. Sandifer? Can you hear me, Ms. Sandifer? Okay. We can't hear you. I don't believe that you're connected to the audio.
She's connected. She needs to turn up her volume or something's going on with her volume.
Can you still hear me? Ms. Sandifer, can you hear me? Okay, again, you may need to turn up your volume, or you may need to log out and log back in to see if you can connect to audio if you're not connected. Okay, we can't hear you, ma'am. I'm sorry.
You're gonna have to log off, Miss Ashland, and log back on and make sure you select the auto correctly in the video to accept on your phone. I will remove you from the Zoom link before you can do that.
Ms. Wells, while we're waiting on her, you can proceed.
Thank you, Judge. Mr. Cruz is 25 years old. He has resided in the state of Georgia for the past 15 years. He was arrested in Cherokee County back in March, and he has been incarcerated ever since then. So he is absolutely indigent. He has been unable to make any sort of income or form of living since that time. However, he did obtain his GED during the course of his incarceration. I just would like it noted again that this incident did occur. This alleged incident did occur in March of last year. My client does deny the allegations as alleged. However, there have been no other incidents or reported contact of violence. I spoke with Ms. Sandifer. She does want to have and maintain contact. She's continued to have contact. She's actually pregnant with this child at this time. I would request a signature on bond. Any bond at this time would be the equivalent of no bond. However, if Your Honor is inclined to give a bond, I would request $8,000 surety bond.
Ms. Sandifer, can you hear us now?
Apparently her auto's not connecting properly, Judge. I don't know what to tell her. It's
Yeah,
something to
can
do
you
with the
hear
device.
me?
Yes.
She's on two devices. She's doing video, and she's doing phone. That's probably why.
All right. Yeah.
Okay.
Can you raise your right hand?
Yes,
Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
yes.
Okay, you can put your hand down. What would you like to tell the court?
Just basically, I just wanted to reiterate what she was saying as far as like not wanting to put the no contact order in place because I am currently pregnant with another child of his. I'm about 5 months pregnant. I'll be due in September. And we have been trying to work through the relationship and make things work, and haven't had any problems since that occurrence happened.
Okay. Anything, Ms. Falk?
Yes, Your Honor. Ms. Sandifer, is it correct that when you spoke with our victim advocate, you did acknowledge that the defendant choked and pulled you by your hair on March 5th, 2022?
Yes.
Okay. And had that happened prior to that incident?
No, it was a one-time situation. Like I said, that was the only time it happened, and it hasn't happened since then. We've been working things out and working on our relationship, and I would like to continue to do that, and for the sake of our family as well.
And just because the report was unclear, what preceded this incident?
Well, we had just got into an altercation, I don't know, like, I can't recall exactly like what started it. I just know that there was a verbal altercation that started. We were just kind of going back and forth with each other, and it just kind of progressed or escalated to that extent.
Okay. That's all for this state, Your Honor. Thank you, Ms. Sandifer.
You're welcome.
Anything further, Ms. Wells?
No, Your Honor.
All right, it's gonna be a it's gonna be a $2,000 good bond. No further violent contact with Ashley Sandifer. No drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Cruz. You also, Ms. Sandifer.
Position 7, Cox.
Good afternoon, Mr. Cox. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Mr. Cox, you've been charged in case 23 CR 003406E with simple battery family violence. Is there a history?
Showing this as the first arrest.
Ms. Falk?
Yes, Your Honor. This happened April 24th, 2023 at 2134 Martin Luther King Jr. Drive Southwest in Atlanta. Satori Williams is the victim in this case. She stated she was at the above location in a recording studio with Aaron Rogers, who is the resident of that studio, of the home where that studio is located. The defendant, her child's father, entered the location, demanded she leave. When Miss Williams refused, the defendant grabbed her by the back of her neck and forced her out the door. Miss Williams was able to get away from the defendant and re-enter the residence. Aaron Rogers, who is the witness and the homeowner, did corroborate Miss Williams' statements, told police the defendant came multiple times, beginning at about 9:30 p.m., which is when the defendant tried to forcibly remove Miss Williams from the home. At that point, when he re-entered the home to try to come after Miss Williams, Mr. Rogers brandished a handgun and told the defendant to leave his home. The defendant then left and returned at 1:45 a.m., dropped off his child with Miss Williams, and then when the door closed, began banging and kicking the door, causing Miss Williams and her son to go into the back room where it was safer. At that point, Mr. Rogers and Miss Williams heard approximately 5 gunshots coming from outside, and although they did not see him fire the firearm, both confirmed that he did have a firearm during these altercations that evening, and that is from the police report. We did have an opportunity to speak with Miss Williams, and I would like to sound for her. She stated she does not want contact with the defendant and that his family are currently sending her threats. For that reason, the state does have concern about the safety for Miss Williams. We are requesting a $5,000 surety bond, stay away from 2134 Martin Luther King Jr. Drive Southwest, no further contact with Satori Williams or Aaron Rogers, and no alcohol, drugs, or weapons. That's all for the state. And we would like to sound from Ms. Satori Williams.
Ms. Williams, if you're on the line and would like to address the court, now is your opportunity to do so. I don't see her, Ms. Falk. Thank you. Ms. Wills?
Mr. Cox is 32 years old. He is a native of Atlanta. He's employed through Ernest Concrete as a driver. He will not qualify to be represented by the Public Defender's Office. He received a high school diploma from Tri-Cities High School. And he has 2 children, ages 11 and 8, who reside in the home with him that he has physical custody of. My client's relationship with the complaining witness is that she is the mother of his children. He states that, and again, this incident happened April 24th of this year. He states that a couple days prior to this date, that she, I believe it's Miss Williams, had left her 1-year-old child, her 1-year-old son, who was not the son of Mr. Cox, at his home to allegedly record music at a music studio with Mr. Rogers. After my client was unable to reach Miss Williams, after calling her and other people reaching out to her in regard to the care of her child, Mr. Cox then went to this music studio to inform Miss Williams that she needed to pick up her child and take care of her child. There was a verbal altercation. However, my client denies any allegations of physical contact between himself and Miss Williams. He did not know and was unaware of the warrant. I don't believe that hearing gunshots on MLK should be attributed to my client necessarily if he was lawfully carrying a gun, and that is not what he's being charged for or charged with. I would ask again for a signature on bond in this case. If Your Honor is not so inclined, I would ask for a bond not to exceed $1,000. My client does not have any objection to not returning to the home of Mr. Rogers. My client states that Mr. Rogers and Ms. Williams are in a romantic relationship, which could be why his testimony lines up with Ms. Williams. But he has no objection to not returning there. He has maintained communication with Ms. Cox in regards to their children, again, who he has primary physical custody of. And so we would like just no violent contact and at least telephonic contact if Your Honor would like to arrange third-party visitation or transportation of the children if that's needed.
Well, it's Miss, I have Miss Williams, so Satori Williams, is that who we're talking about?
Yes, Your Honor, I have the name Satori Williams. And Miss Williams, again, is adamant she wants no contact with the defendant. And I would ask that we not override the wishes of the victim to have no contact with her abuser.
Right, so I just want to make sure that we're all clear on that this is the person that we're talking about. So, and the MLK Jr. 2134, that's Mr. Roberts's residence?
Yes.
Yes.
Mr. Rogers.
Mr. Rogers, Aaron
Mr.
Rogers.
Rogers, okay.
And I did double check the warrant and the report. Her name is listed as Satori Williams.
Okay. So it's going to be a $3,000 signature bond through pretrial per the judge, 1 day anger awareness, no further contact with either Aaron Rogers or Satori Williams. Stay away from the 2134 MLK Jr. Drive address, third party transfer of the minor children for visitation, and no drugs, alcohol, or weapons while out on bond. All right, good luck to you, Mr. Cox.
Position 11, Henderson.
Good afternoon, Mr. Henderson. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Henderson, you've been charged in case 23 CR 003389A with battery family violence. Is there a history, Ms. Roberts?
17 cycles. Last arrest was October of 2022 for driving while license suspended or revoked and knowingly driving motor vehicle on suspended, cancel, or revoked registration. Appears to be on probation out of Clayton County for possession or transfer of a firearm by a convicted felon, home invasion, 3 counts of aggravated assault, and 2 counts of terroristic threats. This is from February of 2018, 3 years confinement, 4 years probation out of Clayton County. 1 FTA 2015, assault conviction 2005 out of Tennessee, driving while license suspended or revoked conviction 2021, 2017, possession of cocaine conviction 2006, and then a CWAC conviction in 2006. And 3 probation violations, 2022, 2020, and 2008, and nothing further.
Mr. Young?
Yes, this incident occurred March 27, 2023 at 3269 Washington Road, apartment 4 in East Point, Georgia. The victim in this case is Jania Felder, if I'm pronouncing that right. Our office has not had any contact, but I believe I did see her on the Zoom call. But the victim told officers that her boyfriend, the defendant, struck her in the face, causing a visible injury after coming home intoxicated. Law enforcement advised the victim of how to get a TPO or an eviction. Given the defendant's history, the state is asking for a $4,000 surety bond, no further contact, a stay away order, 1 day anger awareness, and no alcohol, drugs, and weapons while on bond.
Let's see, I see Ms. Felder on the line. Ms. Felder, if you would like to address the court, now is your opportunity to do so. You, of course, do not have to address the court. If you would like to address the court, I'll need for you to raise your right hand for me. Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Yes, ma'am. What would you like to tell the court?
I will first off like to say I apologize for even being in this situation because we're grown adults and we're parents to 6 children, and we could better communicate with each other about our issues instead of having law enforcement involved, because now this has been rough. A rough 5 days with him not home and helping me. I'm also pregnant now. We just found out that I was pregnant with our 7th child, and I really need help. His continuing help, because we work really well together. We do a lot of things for the community and the kids in our community. So that's what I would like to say. And on that particular day, yeah, I was upset. And yeah, he had been intoxicated at that point, and I just wanted him to stop drinking and just to get away from me at that time of the incident, because of course I just found out that I was pregnant, and I didn't know that I was pregnant at that time. So my hormones and everything was everywhere. And again, I do apologize for having us in this situation.
This happened back in March. Has this ever happened before?
No.
Has it happened since?
No, sir.
Okay. Are you afraid of him?
No.
And is he taking care of your family?
Yes, sir. My children are asking for him every day, especially the 2-year-old. So we really would like him to be home.
Okay, thank you, ma'am. Ms. Wills?
Thank you, Judge. And to your point, Mr. Henderson is 37 years old. He has 3 jobs, one at Cleaner World, one at Cellutronics, where he does electronic repair. And then he also works at the Ultimate Car Wash. So he has 3 jobs to support the 6 children and 7 now on the way, soon to be 7. He is a graduate of James Madison High School. And he was unaware of this warrant, but again, there have been no other incidents. Ms. Felder is not afraid of him. She does rely on him for his income and support in raising their children. My client does deny the allegations as alleged on that date. However, he did state that he would like to attend couples counseling with Ms. Felder. He states they are engaged and they've obtained the documentation, like their marriage certificate and license, but they have not had the official ceremony. So he would like to strengthen work on building their relationship so they can better support the 7 children that they have together. I would request a signature on bond. And if Your Honor is not so inclined, I would ask for a bond not to exceed $2,500. My client does not, he has limited income at this time.
All right, so Mr. Henderson, I would prefer that you are out taking care of your family and your children as opposed to sitting in jail. And I'm going to take into account what Ms. Felder has said to the court and has requested of the court. I'm going to give you the opportunity. So it's going to be a $10,000 signature bond through pretrial per the judge. 1-day anger awareness, no further violent contact with Ms. Felder, and no drugs, alcohol, or weapons while out on bond. If you violate any of these conditions, then you're going to be right back where you are. Just know that that I'm giving you the opportunity to get out and take care of your family. Okay. Courtroom 2, you're on.
All
right.
I really appreciate that, Your Honor. And I have a question.
Hold on, Mr. Henderson. I don't want you to get yourself into any jeopardy. Ms. Wills, would you
Mr.
like to
Henderson,
advise?
yes, I would advise that you do not say anything and relate as it relates to the facts of the case. Do you have a specific question about your bond?
Yes, ma'am.
Okay, what is your question?
I was trying to further understand what did he mean by $10,000 pre-trial bond? I just want to understand.
Okay, it's a signature bond, which means that you're gonna sign yourself out. But it's $10,000 because if you get yourself back into any trouble, it's gonna take you $10,000 to get back out. You understand what I'm saying?
Yes, sir.
So if you get in, if you violate this bond, it's gonna be $10,000 for you to get out, but I'm allowing you to sign your own bond. And you're gonna be monitored by pretrial services until you can get all this resolved, okay?
Thank you, sir.
You're welcome. Good luck to you, Mr. Henderson. You also, Ms. Felder.
All right.
Position 15.
Good afternoon, Mr. Palmerini. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Good afternoon, Judge. Yes, sir.
Thank you. You've been charged in case 23 CR 003396Y with criminal trespass. Is there a history, Ms. Roberts?
9 cycles. Appears to have an open pretrial case, 23 CR 001873Y for disorderly conduct. That arrest was March of this year. That will be a bond surrender. He appears to have another open case for willful obstruction of a law enforcement officer. And I'll waive sounding of the second charge, 22 CR 06470Y. A third open case for simple battery and waive sounding of the second charge, 22 CR 006496Y. And then he had a conviction of this year for unlawful conduct during a 911 call by using vulgar, obscene language to intimidate or harass 911, and nothing further.
Would you place those charges in the chat directed to me, please?
Yes.
Thank you. Mr. Young?
Yes, Your Honor. This incident occurred on May 14th, 2023 at Burger Fire, located at 5475 Windward in Alpharetta. The defendant returned to this location after being after being previously trespassed. So the state is asking for a $2,000 surety bond, a stay away, and no alcohol, drugs, or weapons on bond. We do want to bring to the court's attention that there's an open simple battery of public indecency, 22 CR 006469Y, where he's out on a $4,000 bond, and another public intoxication.
Solicitor Young, I believe the reason that those charges were not stated on the record was to protect the defendant's privacy and safety in the jail. If I just ask that you can withhold those charges, I believe they were sent to the court.
And Your Honor, our response is the same that it has always been, which is we will put that information on the record as we see fit from the state. If the court has an issue with it, there is always the option of taking it off of YouTube.
Okay, so I have received those in the chat. Go ahead, Mr. Young. You're on mute.
On the second case, there's a $3,000 split bond where he's out with a $1,000 surety on obstruction.
Okay, I have the history, so if you could just proceed.
So we're asking for the $2,000 surety and a stay away, no alcohol, drugs, or weapons.
Great. Ms. Holly?
Yes, Your Honor. I actually represent Mr. Palmerini on all of those cases in Judge Edie's division. So I am very familiar with him. This case stems from him riding his bicycle through the eating area of BurgerFi and allegedly going inside, perhaps to use the bathroom. There's no allegation that he was harassing anyone there or doing anything other than being present at a place he had previously been trespassed to. For that reason, I would ask for a signature bond on this case. Obviously, he does have other open cases, which we are aware of and currently working on in Judge Edie's division. And those are actually my cases. So I can state that we are aware of them and working to resolve them currently.
This Windward address, what is that again, Ms. Holly?
It's a BurgerFi. It's a burger restaurant.
You said Burger 5?
BurgerFi, F-I, like Wi-Fi, but burger.
Oh, okay. All right, thank you. All right, it's gonna be a $5,000 signature bond through the jail. Stay away from the BurgerFi and no drugs, alcohol, weapons while out on bond. I'm gonna give you the opportunity to get out, Mr. Palmerini, but don't go back to that BurgerFi, okay?
And Mr. Palmerini, just remember our conversation that means you can't go there under any circumstances. Even if you need to use the restroom, you need to find somewhere else.
Thank you, Your Honor. I will not return.
Okay, good luck to you, sir.
Thank you, sir.
Judge, what was the bond amount? I walked away.
It's a $5,000 signature bond through the jail.
Thank you.
You're welcome.
Position 18, Chavez.
Good afternoon, Mr. Shabazz. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. You've been charged in case 23 CR 003398G with simple assault, family violence. Is there a history, Ms. Roberts?
34 cycles. Last arrest was January of this year for a probation violation out of Fayette County. Appears to be on probation out of Fayette for criminal trespass, 3 counts of theft by taken, and 2 counts of entering auto. The disposition was in 2012, 5 years confinement, 10 years probation. Also appears to be on probation out of Cobb County for theft by taken and burglary. Disposition was in 2014, 2 years confinement, 8 years probation. Has a 2012 willful obstruction conviction, along with a simple battery, a 2002 and 2001 willful obstruction conviction. Theft by receiving stolen property, 96. Battery, 95. Dangerous drugs, 92. Escape, 91. And then a weapons offense with the U.S. Marshals in 2005. I counted a total of 4 probation violations, 1 FTA, and 1 parole violation in 2016, and nothing further.
Mr. Young?
Yes, Your Honor. This incident happened back 9/18 of 2020, where the victim in this case, Aisha Shabazz, she made a 911 call and reported that she and the accused got into a verbal altercation via text. They were meeting up at a gun shop in Fairborn to address ownership of the weapons. However, when he arrived, irate, she drove off because she was scared and she did not know if he had the guns with him. He pursued her around Fairborn, attempted to strike her at a high rate of speed. She ran a red light trying to get away from the defendant, which caused her to strike a vehicle in that intersection of Highway 29 and Highway 138. A video called portion of the chase, and the defendant admitted to chasing her via email he sent to the victim. Our office has had some contact, and it appears that she is on the Zoom call. But she says that the defendant has been harassing her since this incident. They did meet at the pawn shop for the defendant to return her guns. She stated that he has been sending her texts and emails harassing her, and has posted nude pictures and videos online. The victim stated that she has reported these incidents of harassment and damage to a car in Union City, and she believes that he has a case there. The victim stated that she would not want contact with the defendant and wants him to stay away from her. However, she's also on the Zoom. We'd ask the court to sign for her when appropriate. We are asking for a $5,000 surety bond, no further contact, a stay away from the victim's address, 1-day anger awareness, and no alcohol, drugs, or weapons while on bond.
Ms. Aisha Shabazz, I see that you're with us. This is your opportunity to address the court if you choose to do so. You do not have to address the court, but if you would like to address the court, I'll need for you to unmute yourself, activate your camera, and I'll have to swear you in. Does not appear that either Ms. Shabazz would like to address the court or is with us. Ms. Holly?
Yes, Your Honor. So I would like to address some of the alleged facts that the state put on the record. First of all, so during his history recounting, it was stated that his last arrest was, I believe, in January. I would like to put on the record that the defendant has been in custody for 14 months because of this charge. So this warrant, he was not actually, he did not interact with law enforcement at all during this incident. He was actually, this warrant was taken out and he was later arrested on a probation violation from his Cobb case. He was sent to prison. He was then re-arrested immediately from prison on his other probation, which I believe is in Fayette. And then he was just brought here to handle this case for the first time. So he's actually been in custody for the last 14 months. So I'm not sure how the allegations of him sending text messages and emails would be possible within the context of him being incarcerated, especially while he's in prison. He does have a CDL driver's license, so hopefully when he is finally released, he would be able to begin working again. Obviously, he has not worked in over a year since he has been incarcerated. I would also like to state that he does have a hold out of Union City. So we would ask for a signature bond. I understand that the facts of this case are fairly significant, but he is not going to be released. He has to go to Union City to deal with that case as well. So in order for him to be able to go and handle that, we would just ask for a signature bond on this case, especially considering that the case is nearly 3 years old.
And Your Honor, if I may briefly put on the record, as far as his Cobb County cases go, he has 2 separate cases in Cobb County to which he was indicted for February of this year. The first case being an ag assault and simple battery, and the second case being an aggravated assault and aggravated battery. The case number for the first one is 239-00926, and the second being 239-00927. That's all from the state.
So Ms. Holly, did he make bond on both the Clayton and the Cobb
They were probation
charges?
They were probation violations. So he served what he was sentenced to on the probation violations as a result of this charge. And then when he was finished or paroled, he was brought here. First, he was brought to Cobb and then prison and then back and then now here.
Okay, and what is the hold? Do you know what the hold is out of?
It just says Union City. I don't know the nature of the hold.
Given the age of the case and that he's been in custody for the last 14 months, it's going to be a $5,000 signature bond through the jail. No further contact with Aisha Shabazz. Stay away from, just say her residence, and no drugs, alcohol, or weapons while out on bond. So I'm going to release you to that hold, Mr. Shabazz, but you're going to have to come back and address this case. And if you don't, then a warrant will be placed out for your arrest. Okay. Good luck to you, sir. Ms. Holly, it appears that he has a question.
You have a question about your bond specifically?
No, sir, don't worry about it. Thank you.
Okay. I was going to say, if it's about your case, I would hold off.
Okay, you're welcome.
This is going to be an add-on. Mr. Danridge.
There's someone here that wants to also address Mr. Dandridge's case, so I'm going to give them the opportunity to do so at the appropriate time. Good afternoon, Mr. Dandridge. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. You've been charged in case 23 CR 003410Y with criminal trespass and damage to property. Is there a history?
I'm doing 2 cycles. Last arrest was May 2nd of this year for driving while license suspended or revoked, possession of marijuana less than an ounce, possession and use of drug-related objects. He appears to have open cases. The first open case is the last arrest, which was from May 2nd. And then the second open case is willful obstruction of a law enforcement officer, burglary in the first degree, possession of a firearm or a knife in the commission of or attempt to commit certain felonies, possession of a Schedule I controlled substance, and criminal trespass and damage to property, 22 CP 214432. And then he was in felony this morning for felony charges, but I'm not sure of those charges. Nothing further.
Ms. Falk?
Yes, Your Honor. In this case, let me just. This incident happened on May 4th, 2023 at 2:58 a.m. at 281 Fielding Lane in Roswell. When officers arrived, they could hear loud screaming inside of the apartment. They knocked on the door and spoke with Miss Kiana Owens, who stated she and her live-in boyfriend were in an argument. The defendant grabbed her iPhone 11 and smashed it against the wall. The officers did observe the phone. It had smashed glass and was not operational. The defendant then grabbed a kitchen knife and began cutting his left arm. He then locked himself in a room, and eventually the police were able to access the room and transported him to North Fulton on a 1013. The state's recommendation, and I just wanted to take a moment to look at the bond conditions on his 22 CP 214432 case and make sure it is not involving our same victim, which it does not appear to be. So the state's recommendation on this case would be a $1,000 surety bond, no alcohol, drugs, or weapons, no further contact with Kiana Owens, stay away from 281 Fielding Lane in Roswell. The state would also like to sound for Ms. Owens at this time.
So, I know that you're here. If you will activate your camera for me, raise your right hand. Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you, ma'am. What would you like to tell the court?
Okay, so not all of those charges, the charges that happened here of whatever the officer is saying, that's not what happened here at all. So when they did come, we were not arguing. There was no loud yelling, any of that. We don't yell here because we have thin walls. Marvin was going through something. He was having a mental breakdown. I was calming him down. He was not cutting his arm. There was a knife on the kitchen counter that he had nothing to do with. What's it called? When they did come in and inspect the house, they seen that one of my phones, because I have two phones, one of the phones was broken on the couch, and they asked to inspect it. They asked me what model it was. I told them it's an iPhone 11. They didn't ask me about him breaking it because he didn't break it. They searched the room, my bedroom. They said, did he damage any other property? That was his specific words. I said, no, he didn't touch anything. He didn't throw anything. He's just going through something. He's having a mental breakdown. Nobody was arguing in the house. When they did, he didn't lock himself in the room either because these doors don't lock. He was asleep when they came in here because they told me, I told them, they asked which one is the bedroom, what's the bathroom? I said, the bedroom is on the right side. He was asleep when they arrived because they had to wake him up and get him out the house or whatever. And I kept asking to talk to him. They would not let me speak to him. They wouldn't let me back in the house. And so they were making up all these assumptions of what were happening. They weren't actually writing down exactly what was going on in the house or whatnot. So for him having the mental breakdown, they did ask him if he wanted to go to a hospital. He said yes. So he was at the Peachford Hospital. He stayed there for about 6 days. And he was treated there to help what he was going through. Came back, they diagnosed him with depression,
Maybe this is
or whatever.
more breakout.
Okay.
He's getting into a
Yes.
lot of details about his.
Sorry.
Yes, yeah.
So I have enough information about that, Ms. Owens. Anything further? I understand what you're trying to tell the court, okay?
Yeah, as far as him not being in contact with me, he lives here. He's under my lease. We don't have any problems with each other. We don't argue, and I don't get why he wouldn't be able to see me. We have a baby coming in 8 days, and he's been supportive of it the whole time. We have a doctor's appointment on Thursday. He's the only one that takes me to my appointments, and besides him, his mother, who lives in Florida, is our only support system. We don't have a support system in Georgia. So I don't understand why he wouldn't be able to be in contact with me And
Okay,
like,
and you're not afraid of him?
no, he's not
Okay.
an aggressive person, no.
All right, thank you, Ms. Owens. Ms.
You're welcome.
Wills?
Thank you, Judge. My client is 19 years old. He has resided in the state of Georgia for the past 4 years. He is employed by Walmart as an online shopper, and he's been doing that for the past, over the past year. He is also a student at Atlanta Technical College for IT security. He will not qualify for our services. He does have a high school diploma from Milton High School. He does deny the allegations as alleged. I would ask that there be no further violent contact. And speak with my client, he did mention the fact that he's anticipating his first child being born any day now. This incident did occur earlier this month. If Your Honor is not so inclined, I would ask for a bond not to exceed a $500 surety bond. My client already has a $10,000 bond that he received this morning. And I would ask for no further violent contact between himself and the alleged victim.
Okay, for this particular charge, it's going to be a $3,000 signature bond through the jail, no further violent contact with Ms. Owens, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Dandridge.
Thank you, sir.
Welcome.
Judge, I have a quick announcement for position 2. We waive their appearance.
Okay. And is that the last one?
And also, position, well, you guys already did position 20, waived appearance. I was doing a breakout, and that's it. Judge Rick.
Okay. All right, thank you so much. I appreciate it.
All right, thank you. Have a good one. Be safe.
Do the same. Thank you.
Thank you.
Let's see, for Hope Allen, charged with battery, family violence. Is there a history?
I'm showing 3 cycles, with the last arrest being in 97 for forgery and financial transaction card fraud, which was dismissed, and 1 conviction from 94 for deposit account or bad checks.
Ms. Falk?
State is recommending a $3,000 signature bond through pretrial, no further contact with Betty Allen, no alcohol, drugs, or weapons, 1-day anger awareness, and stay away from 1835 Sylvan Road, Southwest Atlanta. This happened when Betty Allen, who's 75, and her niece, who's 51, the defendant, were in an altercation over use of the kitchen stove. Miss Betty Allen suffered lacerations and scratches to her face during the scuffle, and both of them were arrested. I believe Betty Allen did not get booked in until after the cutoff, so she'll be coming to court tomorrow.
Okay, so I'm sorry, Ms. Falk. Tell me again, as far as the contact and the stay away.
State is asking for no further contact and a stay away between these two.
Okay. Ms. Wells?
Thank you, Judge. My client is 51 years old. She is an Atlanta native. She has a master's in business from Georgia State, and she currently is a youth minister with New Birth. She will qualify to receive our services. So she has very limited income. She also shared with me that she recently had a surgery on her foot, which is why she did not appear in court today. It's very difficult for her to get around physically. She is related to Miss Betty Jean Allen. That is her aunt, who is 75 years old. My client stated that her aunt has, I guess, onset of Alzheimer's. So they are both wading through that together with my client's physical injury, as well as with Miss Allen's, just what she's going through mentally. She denies the allegations as alleged. She states that she was moving the pot and Miss Allen, her cross defendant, there was some kind of, she grabbed the pot out of nowhere, but it was not her intent to harm her aunt. She has no desire to harm her aunt. She believes it was just a big misunderstanding. This is where they both live together as aunt and niece. I would ask that there be no further violent contact between the two of them. And my client stated that she has no concern that they cannot coexist peacefully between her doctor's appointments, with her follow-up for her medical care, and also with her church engagements. So that would be my request. I have obviously no objection to a signature bond for my client.
Okay, so it's gonna be $3,000 signature bond through pre-trial, 1-day anger awareness. As for this defendant, there will be no further violent contact with Betty Allen, and no drugs, alcohol, or weapons while out on bond. Who's ever in court tomorrow, I guess they can assess Miss Betty Allen's condition, and if they decide that there's to be no further contact, then then they can do that. But as far as Miss Allen goes, there'll be no further violent contact. Okay, anything, I believe that completes today's calendar. Ms. Bridgewater, did you have something, Ms. Falk? I'm sorry.
No, nothing further from the state, Your Honor.
Okay, thank you. Ms. Bridgewater,
Yes, sir.
whenever you're ready.
Okay, I'm ready. Once again, the reset date for the SAP calendar is going to be June the 13th. Position number 1 is reset further notice with a $2,000 SOB through the jail. Position 2 is reset further notice with a $3,000 SOB through pretrial. Position 3 is reset further notice with a $4,000 total SOB through pretrial per judge. Position 4, reset further notice with a $3,000 SOB through pretrial. Position 5 is reset further notice with a $3,000 SOB through pretrial per judge. Position 6 is going to the SAP calendar with a total $4,000 good bond. Position 7 is, okay, I'll come back to that one. Position 8 is reset further notice with a $3,000 SOB through pretrial per judge. Position 9 is reset further notice with a $3,000 SOB through pretrial. Position 10 is going to the SAP calendar with a $2,000 good bond. Position 11 is reset further notice with a $10,000 SOB through pretrial per judge. Position 12 is going to the SAP calendar with a $15,000 good bond. Position 13, reset further notice with a total $6,000 SOB through the jail. Position 14 is reset further notice with a $3,000 SOB through pretrial per judge. Position 15 is reset further notice with a $5,000 SOB through pretrial. I'm sorry, $5,000 SOB through the jail. Position 16 is reset further notice with a $3,000 SOB through pretrial. Position 17 is reset further notice with a $3,000 SOB through pretrial. Position 18 is reset further notice with a $5,000 SOB through the jail. Position 19 is reset to the competency calendar for June 8th with a $2,000 total good bond. Position 20 is reset to the competency calendar on June 1st with a $1,000 good bond. Position 21 is reset further notice with a $3,000 SOB through the jail. And the add-on is reset further notice with a $3,000 SOB through the jail. And going back to position 7, let me look through my paperwork. It is reset further notice with a $3,000 SOB through pretrial. Are there any questions, comments, or otherwise?
Yes, position 8, Jimmy Cruz, I had a $2,000 surety bond on that one.
Position 8, I show that you show that it's a $2,000. I have a $3,000. Does anybody else have $2,000? $2,000 SOB through pretrial?
No, surety bond is what I'm showing.
Okay. So that will be set to the SAP calendar. Are there any others?
All right. If not, thank you all.
Thank you, Your
We'll
Honor.
see
Thank
you
you,
next
Mr.
time.
Bridgewater.
Yes, y'all have a good evening.